So there has been changes with the decisions and implementation that we usually receive in relation to EEA family permits that were made before the deadline of the 30th of December. What we have noticed is that unfortunately both the Home Office and the UKVI and entry clearance officers are not implementing positive appeal decisions or appeal decisions that have been successful at the back of EEA extended family applications that have been made. We've also noticed that in addition to not implementing appeal decisions, they are also refusing to make decisions in relation to applications which were made before the deadline of the 31st of December that were decided after the 30th of June. This is causing enormous difficulties for a lot of our compatriots and our community, and this is to explain what exactly to do. First of all, under the withdrawal agreement, the UK government is bound by the terms of the withdrawal agreement in relation to implementation of those decisions and areas that have been agreed prior to the UK leaving the European Union. And this is termed as a Brexit agreement. As part of that process, timeline was set for family members and extended family members. And extended family members who made an application before the deadline of 31st of December were supposed to be protected. Indeed, just Friday, the Home Office have come out to say that applications made before the deadline and also after the deadline will have their rights protected by the Home Office. It is therefore our considered view that this position by the Home Office to refuse to implement positive successful appeals or to issue family permit on the basis that the family permit will not be valid for travel to the UK is a travesty and unlawful. We say it is unlawful because within the law, the Home Office is required to implement appeal decisions that have been allowed. There's a lot of case law to this effect, and their own policy guidance to caseworkers at the Home Office, the latest one is August 2020, has confirmed that when the Home Office fails to appeal within the requisite statutory time period, they ought to implement the decision of the court. And therefore, not implementing the decision goes beyond what the Home Office can or ought to do. In those instances, our advice to clients is to lodge an official complaint and also send a pre-action protocol letter notifying the Home Office that if they were not to implement the appeal decisions, an action for judicial review will be brought against them. We are aware that other solicitors are also taking this step, and indeed 𝗓𝗵𝗋𝗀, which is the Immigration Law Practitioners Association, is collecting evidence of other applicants who may have suffered similar fate. At the back of this, we've also noticed, rather unfortunately, that the Home Office are refusing to make decisions and grant family permit in cases where the application would have been successful. This for extended family members again. And again, the explanation, which we say is unlawful, is that even if they are given the family permit, they will not be able to travel with a family permit because it will be invalid. This we dispute because within the law, an extended family member can make an application for EU settled or pre-settled status, or EU settled status or pre-settled status from outside the UK. However, every extended family member is required to have a relevant document. And the definition of relevant document at Annex 1 of the relevant law, which is Appendix EUFP, is 1, either a family permit, or 2, a residence card. It is therefore our position that failure to issue a relevant document to enable the extended family member reapply under the relevant law is unlawful. And it is these factors which we say the Home Office ought to take into consideration, because they have not provided any other avenue for redress. And it seems the only option is to bring judicial review. We hope this is helpful to you. And if you want more information, please contact BWF Solicitors 0208-493-7340. 0208-493-7340. Alternatively, you may send an email to us at admin@BWF Solicitors or visit us on our website. You may also follow us on social media handles: Facebook, LinkedIn, Instagram, and YouTube. Thank you very much.